crossing, running across, late to class as usual. There we go. Preserved on the video camera. All right, so good afternoon, ladies and gentlemen. Have attention, please. All quiet, please. Thank you. Go ahead, have your notes out. We're going to get right back into civil rights, criminal justice rights, with examples of various different criminal justice things and so forth. Some of them actually from my old legal career from way back when. And actually, there may be an opportunity. We'll see how we're going on this and so forth. I want to say no more, only up to 10 minutes maybe, walking down to the choir room, the band room. We're going to go chop, because the seniors are doing their class showcase, where they've been doing lots of volunteering, all kinds of cool creative things throughout the year, and they've got that showcase thing. We march you down there, then you have an opportunity to ask a few questions and talk to them and so forth, and go, whoo, isn't that cool? Because all the seniors are involved in that, whether they're on the IB track or the VC Venture Capstone track. So yeah, anyway, that's going on. Questions? No, when I say so. Okay. When I say so. You have to wait on Mr. Hansen says, okay? So yeah, Miss Beglinger sent a thing out trying to get us all scheduled and so forth, and I'm like, but here's the deal. Shh. I had the other 10th grade class for a whole half an hour or more yesterday, although we just got as far as you guys did the day before. So needless to say, let's get right to it, shall we? Okay. No, actually, they've got all kinds of really good scenarios and different things and so forth, all kinds of really cool questions, and yeah, no, this is good, which is all good. Okay, here we go. Last time we did the Fourth Amendment, okay? So, Gabe, if the police violate the Fourth Amendment and conduct a search without a warrant or without any reasonable suspicion and doesn't fit into any exceptions, what's going to happen to the evidence obtained? Right, that's right. It's going to be, the word is excluded, according to what Supreme Court case? You gotta know your cases. Okay, raise your hand if you know what Supreme Court case has the exclusionary rule. Rapp versus, I like that. Rapp versus, yeah, Mapp versus Ohio, 1961. That was the name of the case. Okay, Mapp versus Ohio. Okay, good. Let's go into the next one. Sixth Amendment's got lots of different things in there. Write this down. The Sixth Amendment. One of the things that's in there is a right to have an attorney in a criminal case. All right? Fair enough. The Supreme Court has added some words, and some of it is sort of like, well, that's not really adding words. I mean, that's just like, hello. Of course, you've got to have competent counsel. Competent. In other words, competent. As in, like, they know what they're doing. They're doing a good job. The opposite, what is the opposite of competent? Very good. Incompetent. Hey. Be nice. Yeah. Okay, yeah. Because if you are an attorney and you put yourself out and get hired as an attorney in a criminal case and you make mistakes that don't help your client, write this down. You ready? This is quite clear. If you make mistakes in the case, like you don't call a witness who would have been really helpful for the defense in their case, you don't call them. Or you fail to make certain objections. Like, oh, I guess we should have objected to the introduction of that evidence that was obtained in violation of a Fourth Amendment. Didn't have a search warrant. Whoa, oopsie, my bad. The defendant has a right, and they will do this. They will say, my rights have been violated. I had counsel. I had an attorney. And I thought they were doing their job. But after I lost, another attorney came in and said, oh, your previous attorney, oh, this and this and this and this. Let's appeal and say that your Sixth Amendment right to competent counsel was violated. Now notice this, write this down. If you win on that kind of an argument, that my attorney in the criminal case, the trial, was incompetent, made mistakes and so forth, that lost me the case. In other words, I was found guilty. If you win on that on appeal, what do you think, Daphne? What are you going to get? I'll give you two choices. The case is thrown out. The case is retried. Retried, exactly. So, I mean, it's better because if it's retried, you might actually be found not guilty on the retrial. Notice this. In fact, I want you to make a little note of this. If there's a case that goes to the jury and the jury comes back not guilty, can the state appeal? No. Once that not guilty verdict has come in, we'll see when we get to the double jeopardy, that's it, folks. It's over. There's no retrial for the prosecution, but for the defense, you could get a retrial in this situation. Yep, same difference. The same thing applies. Okay, you could have a federal criminal case against you. You could have a state criminal case against you. In fact, most criminal charges are brought where? State courts or the federal courts? State, yeah. Yeah. Let me just think of, if you think of all the number of people who are employed in law enforcement, most of them are employed by state and local, and then there's some that are employed by federal.
What is it called when you lie?
Perjury. Lying under oath about a serious issue. That's a separate criminal charge.
Yes, if you find out after the trial that they were guilty, but they were found not guilty, and you can't do them for double jeopardy, can you charge them for perjury?
Interesting question. I'll handle this. Did you guys understand the question?
Yeah.
For the sake of the question, Caden, just for the funsies of it, we're going to make you be the person who's charged with a crime and who lied under oath. Okay? So you got, no, it's not good practice, but anyway. So you were tried, and you went to the jury, and you were found not guilty. Can we bring the charges against you when we've got really clear evidence that you were lying under oath? No. Double jeopardy. Once that case has gone all the way through, double jeopardy. I didn't say that. The next question is, can we charge you with a separate crime of perjury? Yes. Okay? Yes. Okay, that's a different thing. Now, if the original charge was like homicide, murder, that obviously is going to have a much, much higher penalty. Do people lie under oath in trials? Criminal defendants, does that happen? It does. Was not under oath. That was not under oath. Okay, the other one that he did get impeached in the House of Representatives, that wasn't under oath thing, and so that was a much, much more serious thing. Perjury, I mean, you have to look and so forth. Could be jail time. I don't know if there's like felony perjury. There may be. Okay? All right. Let's go into this one. 1963. The Supreme Court gets active. Write this down. Okay? We got a little bit of activism, as in the Supreme Court's going to read the Sixth Amendment to say that you have a right to a competent attorney. Because other people would go, hey, if you go to the store and you buy really poor quality stuff for a really cheap price, and then it doesn't work out very well, I mean, that's just you. You bought a cheap thing, and that's what you get. But for an attorney, you still are entitled to a competent attorney. Well, what if you can't afford an attorney? Here we go. Here's the story of Gideon. Gideon is the man right here. He was a criminal defendant in Florida. He was charged with homicide, okay? Killing somebody. A very serious charge in a state court. Yes, in which killing people, a person. And he was like, I need help. Now, write this down. In the 1960s, early 1960s, there were a number of states that did provide for some legal assistance to poor people. There were also a number of attorneys that would volunteer all or part of their time to help poor criminal defendants. Okay? But there wasn't something absolutely set in stone. And there certainly wasn't in his case. Make sure you have this. Gideon asked the court to appoint a so-called public defender. In other words, an attorney that he didn't have to pay for. And they said, no, sorry. You're not entitled to that. And in fact, they could say, there's nowhere in the Sixth Amendment that it says that the government has to pay for the attorney. And his argument was like, well, the government's paying for the other side. The people, the taxpayers are paying for the other side. and they've got a pretty good prosecutor that knows what they're doing in court. I mean, he was actually very eloquent in the sense that he said, I don't know what questions to ask. I don't know who to call. I don't know anything about how to handle all the evidence and admission and all the court proceedings. I don't know that. I need an attorney. And they said no. And the Supreme Court eventually, who was the Chief Justice of the Supreme Court at that time? Earl Warren. Now, don't put it all on Warren, but the Warren Court. The justices of the Supreme Court, most all of them, were very much more open to reading the Constitution in such a way that it was fair. So reading things into it. So they were much more activist. In fact, they would say, look, we don't think criminal defendants are going to be capable of getting the Constitution amended to have this requirement of a public defender. So what did they do? Gideon versus Wainwright, there's the case. The Sixth Amendment now is interpreted to say you are entitled to a public defender if you cannot afford one. Let me be clear about this, because let me just clear this up and let's see if you got some follow-up questions on this. In the state of Idaho, this is how it is interpreted. If you are facing a criminal charge that could get you in jail or more, like prison, you are entitled to it if you can show that you're poor. Okay, do you understand that? So you can't just walk in and go, well, I want you, the government, to pay for an attorney. Well, yeah, you've got a lot of money there, so I don't want to spend my money that way. Sorry, you don't have that right. So they'll actually have you fill out a form showing like where your income is and how much property you have and so forth. And so you can write this down. You may get a public defender full price, as in you don't have to pay anything. Or if you're sort of poor, you might have to pay back half. Does that make sense? Put this in as well. I said if you're potentially facing jail or prison. If you got a speeding ticket, or you get some kind of a really low-level misdemeanor where all they're going to do is like fine you a charge. In fact, the judge could say, I'm sorry, but even if you're found guilty, you're not going to jail on that one. In Idaho, you are not entitled to a public defender in those circumstances. Okay? Low-risk circumstances. Do you understand that? Okay, so do you see what the boundaries are of that right as defined by the United States Supreme Court? It's activist, but nevertheless, that's the way it is, and it hasn't been changed since 1963.
So, can cases only come to the Supreme Court, or can the Supreme Court really take
Very good question. The case has to go to the Supreme Court. I mean, as in, it's got to make its way up through. I gave you the wonderful example of like the Pledge of Allegiance case, where people are like, I don't know, is that a violation of the First or not? They can only take that case if something makes its way up through properly. And if it doesn't, then they never get a chance to rule on it. It's a very good question, because sometimes people might think, oh, well, the Supreme Court can take up anything it wants whenever it wants to. Not exactly. Okay? Because that's not their job. They are the court of last resort, and it's got to work its way up through the system. Okay? Now, you know some cases are going to. When George W. Bush ran for president the first time and Al Gore was running against him and so forth, that case, as far as like how they count the vote in Florida and so forth, I mean, that started out in the lower courts, and that went on a fast track. Same thing with the Biden-Trump race, as far as like some of those cases that made their way up to the Supreme Court very quickly. Okay? And we'll see when we get to the abortion case. That actually went pretty quickly because there's a time element. Once you guys got started, how many more months was it before you made your debut?
9.
Yeah, 9 typically, although some people show up early. Okay? And if you guys show up early? It's a personal question. There we go. Yeah, kind of, yeah. And if you guys show up late, you're like, yes, I was a 12-month gestational period. No, that's not, I mean, no. 2 weeks late? Really? Wow. Wow. Okay. Oh, we're not going to do that one. We don't have time for that one. Let's go to Fifth Amendment. Fifth Amendment, double jeopardy. Okay, here we go. Listen very carefully to this. Part of the Fifth Amendment, because it's got all kinds of various different component parts to it, is the double jeopardy part. Okay, you cannot be tried again for the same crime after an acquittal. An acquittal is another way of saying the jury came back with a not guilty verdict. The person was acquitted. Or if the judge dismisses the charge with prejudice. I'll clear up this. It won't take too long. Sometimes the prosecutors bring a charge on someone and then they drop the charges. Okay? It could be a variety of different reasons. Can they charge that person again? Yes, they can. Yeah, they have within the time frame of the statute of limitations. So if there is, a 1-year statute of limitations, they're like, okay, we got the charge against you, and they're like, oh, wait a minute, we're on the court date, we don't really have everything, so they dismiss the charges without prejudice. Without prejudice. They can bring them again. So when would a judge say, I'm going to dismiss this thing with prejudice, and you can never bring this thing back again? Ready? Write it down. Prosecutor or law enforcement misconduct. Okay? Misconduct. As in, here's a good example. Prosecutor and law enforcement, they got all kinds of evidence against the defendant, but they also have some evidence that will help the defendant. When you're the prosecution, when you're law enforcement, what kind of evidence are you supposed to get? Just the stuff that'll help make the defendant look bad, or just everything that's relevant? Everything that's relevant. And if you find out something that's relevant, and that is, ooh, you want a fancy word? Exculpatory? What do you suppose exculpatory means? Who does exculpatory evidence help? The defendant, because it helps it look like maybe if the jury got that piece of evidence, they might go, I don't know, maybe I've got a reasonable doubt that the defendant did it. So here's the deal. If the prosecutor or law enforcement hides that evidence, because they're supposed to let the defendant and the defense attorney know about it. You can't keep secrets from the defendant and the defense attorney about stuff that could help their case. And if you do, thinking, oh, we're going to hide that because we want to win. No, it's not your job as law enforcement and the prosecution to just win. Your job is to public safety, okay? If you've got enough evidence to win a case and put somebody behind bars, great. But if the evidence is got a lot of exculpatory evidence that helps the defendant, you got to let them see it. So here's what the judge will say if they find out that you were playing fast and loose and not following the rules. They could dismiss that case with prejudice. Therefore, are you going to ever be able to bring that case up in front of a jury for a trial? Nope. Double jeopardy. Do you understand that? So don't cheat, lie, steal, be a little unsavory if you're the good guys, supposedly, the prosecution and law enforcement. Yeah.
So, it can only be because prejudice if it's prosecution or law enforcement misconduct in court.
In the case.
Yes,
In the case. That's the biggest one. I mean, there may be some other kinds of things and so forth, but that's the one that's the big area that kind of comes to mind.
Misconduct case.
Yeah, misconduct in the case. Okay? Yeah, basically hiding stuff that could help them out. Yeah.
So, there's if you found not guilty of one charge, can you be charged again with a related charge?
That's a good question. How closely can you make it? Here's an example. You ready? Okay. Let me give you an example, because sometimes it's like, I don't know. The Rodney King case, it happened a long time ago, before you were born. I want to say like 1990. Okay. Okay. Yeah. Really? Weren't you? Oh, that's interesting. So Rodney King, remember, he was a African American who was arrested by white Los Angeles Police Department personnel, police officers, and they recorded him being taken into custody, or as many would characterize the video, being beaten by the police. In other words, the police ultimately were charged. It was like the whole Siobhan case, okay, only it turned out different. Siobhan was found guilty in Minneapolis, right? You guys are aware of that, right? He's going likely to prison for a fair amount of time. The Los Angeles Police Department officers, I'm going to say there was like 3 or 4-ish, they were found not guilty in a state case. Okay, and of course, a lot of people were paying attention to that, and there was some writing, and people were not very happy. Could they be charged with that same crime again in California state court? No, double jeopardy. Okay, but it was interesting because the federal prosecutors looked at the case, looked at the facts, and says, aha, I think we can charge them with the federal crime of violating Rodney King's civil rights. Violating Rodney King's civil rights. Well, what are the facts that are different than what they did in beating him up while they were taking him into custody? Well, in violating Rodney King's civil rights, the charge was beating him up while they were taking him into custody in such a manner because he was African American. So the courts deemed that there was enough new stuff in that fact situation to say double jeopardy didn't kick in. And so there were federal criminal charges brought against those police officers in a federal court. A federal criminal jury found them, I think at least 2 or 3 of them, guilty of some of the federal charges. So it's very interesting on how that is, okay? And then I'm going to get to this crazy film, which is like, who writes this stuff? Yeah. Liability, that's separate. Can you be sued in civil court? Absolutely. It's a different standard altogether. So O.J. Simpson lost the civil case, had to pay money, won the criminal case, never had to face those particular criminal charges again.
So can a federal case versus civil, or is it always?
Oh yeah, there's federal civil trials. Oh yeah. Yeah, they've got civil and criminal in the federal courts as well as the state courts. Okay? Now, let me give you the plot behind the movie Double Jeopardy. Okay? And then I will show you the trailer. Actually, let me show you the trailer first and then we'll discuss it. What's that? Yeah. Okay. Okay. All right. Here is Tommy Lee Jones and Ashley Judd in the trailer for the movie. I love this. Murder isn't always a crime. Double Jeopardy. Okay. Let's take a look at the trailer because you're going to see. Really? Seriously? Skip. Oh, happy beginning. Oh, thank you, Daphne. Oh, it's a happy story. Oh, it's a happy movie. And then she wakes up with her husband's blood on her hands. And where is his body? Her fingerprints are all over the knife. Nick? You're supposed to be dead. Always take legal advice from somebody in prison. You can kill him. You can just kill him. Hello, Nick. Oh, do you feel like you watched the entire movie there? All right. So there's a number of different levels of analysis on this particular one. Okay. Does the husband deserve death? Oh, there we go. Yes. Right? Because what did he do? Yeah, and he married her friend, and then he killed her friend. Oh, and then he took on this fake Southern persona, he's ooh. So Hollywood justice, he's got to die. Okay, but here's the thing: they said double jeopardy, right? The prison cellmate said, there's a thing called double jeopardy. If you're found guilty for committing a crime, then you can't be charged with that same crime again. Is that what double jeopardy says? No, it doesn't. What does double jeopardy say?
You can't be tried twice in the same case.
Right, as in, if you're found not guilty or it's dismissed with prejudice, then that's it. Then the case goes away. This isn't the same thing.
If you do the crime again, you still get charged.
Go ahead.
She gets charged for killing the same person twice.
Yeah. So here's the deal, right? Hopefully you guys picked this up from the trailer, all right? It was a setup. She's accused of killing her husband in order to collect insurance proceeds, and there's blood all over the place, and she's got her fingerprints on it, and she's found guilty, and she's stuck in prison, and she hates it, right? So she's not very happy. But ultimately, turns out he's not dead. He is alive. So let me ask you this question. Sorry, I'm going to blow this one for you. Write this down. Double jeopardy. If the charge that you are convicted on is such that, like in a murder case, what is one of the key elements to prove for the prosecution in a murder case? There's a dead person. Well, I love this. In criminal law and law school, they have this one case where somebody gets tossed off the boat, right? Okay, and so somebody's charged with murder, tossed off a boat, and all they can find of the dead body is part of a limb in the belly of a shark or something like that. Is that enough of a body? No. You don't need all your limbs in order to continue living and so forth. You could be missing a limb and still be alive. So, yeah, in this case, the guy is all alive. Yeah.
Wasn't there a case at some point where somebody was convicted, yet it wasn't a body?
It's going to be tough. It helps to have a murder conviction if you have the body. But you could have other circumstantial evidence that the court might deem, okay, that's good enough. Wow, we're missing a body, but, the person is being accused of pushing them into a volcano. It's kind of hard to retrieve, Gollum at the bottom of the Mount Doom and so forth, And even the ring is gone. So here's the deal. Sorry, spoilers. If there is a guilty conviction, but it's not supported eventually by the evidence, what is the court going to do? Remove the case, right? They're going to basically throw out the guilty verdict, and they'll say, I'm sorry that you were found guilty, and you spent a whole bunch of time and so forth in prison. And he would be in a lot of trouble for manufacturing false evidence and so forth. I mean, that's a big thing. But can she then go out and kill him again, since supposedly she was found guilty previously of killing him? No. But in the movie, does the audience want the guy dead? He's good.
I mean, I've never seen it, but I think the guy is killing him, and then the police find out that she actually did. She's not really helping her case. Why couldn't she just prove that he was alive? She could just poison him, and then he
There's Hollywood justice, and then there's legal justice. She could. He's alive, but is she going to be satisfied with a civil jury verdict for money, or is she going to be satisfied with a criminal jury verdict where he gets thrown off for fraud on the courts and insurance companies? She wants exactly. And who's going to look after her son? Not her husband, yeah. And her friend is gone there too. Oh my gosh, who writes this stuff? Translation, write this down. Oftentimes, in Hollywood, they don't necessarily follow all of the particulars of constitutional law, but that's okay. Sometimes that just gets in the way of a really good plot, right? It gets in the way of a really good plot. Okay, and I got a great case on this one. You want to hear my story? You want to hear my story on the Sixth Amendment, Idaho versus Wright, because I was involved in this one. Oh, but wait, you'll have to come back, because I'm going to take 10 minutes. We're going to walk down to the choir. We're going to walk down to the other room. We need to be back here 2:28. Okay, so go down, talk to the different peeps. Okay, do you guys know where the choir room and the band room and so forth? Talk to the seniors, and then turn right around. Okay, you guys can go. Go, chop, chop. Cast project. Go talk to the seniors. Chop, chop.